Commissioners, and our candidate today is Alice Yano. Welcome to this session. We want to thank you for availing yourself. And we'll start by introductions. And today I'll start on my left. So I'll request the Honorable AG to introduce himself, and then we'll go around.
Very good morning, Madam.
Good morning.
Kehara Kariuki. I am the Attorney General, and I'm here by virtue of that office.
Pleasure.
Good morning, Wakili.
Good morning to you.
My name is Mohammed Warsame, Judge of Appeal. Welcome.
Thank you, my lord.
Good morning, Wakili.
Good morning, Commissioner.
My name is Felix Koske. I represent the public. Welcome.
Thank you.
Good morning, colleague.
Good morning.
My name is Machari Njero. I represent the Law Society of Kenya as a commissioner with the JSC.
Thank you.
Good morning, Wakili.
Good morning.
My name is Olwande Evelyn. I'm a Chief Magistrate representing KMJ in the Commission. You are welcome.
Thank you, Your Honor.
Good morning, Council. My name is David Majanja, Judge of the High Court, and representing Kenya Magistrates and Judges Association as the male representative.
Thank you, my lord.
Morning, Council. I'm Patrick Shohi. I represent Public Service. Karibu.
Thank you, Commissioner.
Good morning, Council.
Good morning.
My name is Philomena Mbetemuilo. I represent the Supreme Court. I'm also the Deputy Chief Justice of the Republic of Kenya.
Thank you, my lady.
And my name is Olive Mugeda, Commissioner representing the public. And we also have our Chief Registrar of Judiciary, Anna Madi.
Good morning, Council.
Good morning.
Yes, and also we have our Registrar, JSC, Frida Mukaya.
Thank you.
So, please feel free to ask for clarification, please, if you are not sure about a question. And after 2 hours, we normally take a break. And our Chief Registrar will guide you where to have that rest, where to sit. So welcome to the interview. And I will start with the first question. Just looking at the profiles, you are the youngest candidate to apply for this job. And I really congratulate you for your big dream.
Thank you.
My question is, what informed you on your decision to apply for the CJ job? Just briefly, maybe 5-10 minutes.
Yes. Thank you very much, Chairperson. Yes, I'm one of the youngest in terms of application, but may say that I'm not the youngest in terms of experience. And why do I say so? I have a short, brief history. I was born in a family of almost 25 children, a polygamous family. I am the firstborn, and I became their leader when I was very young, taking care of them. Thereafter, I would want to give out my story. I was born and brought up in Nakuru. Later, I went to a primary school called Menengai Primary School in Rongai, Nakuru. I proceeded to Kipsigis Girls, then to Solian Girls, then to the University of Nairobi. Chairman, the issue of being young was manifested in me, that is leadership in me, when I was waiting to join the university in 1989. I was called to start a secondary school called Kirobon Secondary School, and I started it from the scratch. At that particular time, Chairman, I was only 21 years old, and I was the headmistress of that school. From there, Chairperson, I joined UON to pursue LLB. That was in 1989 up to 1992. And while at the university, I was made a class representative and also representative to the Senate. Issues of disciplinary issues affecting students, I was in charge at that particular time when I was in Parkland's campus. Still, I was very young.
Councillor, are you referring to any material? Because we prefer that you just talk to us without referring to any written notes.
Oh,
thank you.
Thank you, Chair. I think I'm used to writing. That's a problem with advocates in court. From the University of Nairobi, Chairperson, I joined, we had a short stint outside. We couldn't join Kenya School of Law on time. We joined Kenya, we finished in 1992 and joined Kenya School of Law towards the end of 1994. It was a problem of the double intake. While I was in that limbo, I joined Kenya Industrial Estates, where I became the legal officer with attendant duties of drafting documentations, advising investors and all that. Then thereafter, Kenya School of Law, wherein I completed in 1995. After completion, I got married, moved to Eldoret, and set up a family. I am a mother of 2 children, grown-ups. Unfortunately, I lost my husband in 2012, but life has moved on. In Eldoret, I opened up Yano and Company Advocates. That was towards the end of 1996. And that is the law firm I still run up to date. Despite other engagements I've been getting from side to side, the main engagement that I've been running from 1996 to date is Yano and Company Advocates. While in Eldoret, we formed a group. We called ourselves the few, at least, enlightened women. We formed a group of about 6 ladies, and we said, what is it that we can give to the society? And the most important thing that we did is we came up with an NGO called RWIBIS, Rural Women Empowerment in Basic Services. And what did we do with this group? We realized that in the village, and especially Elgeyo Marakwet, our people were not very well economically endowed. And the majority of the affected were women and children. So that the moving factor was we had more of the mud hut houses, the grass thatched houses. And we made it a point to encourage our women to come together, to fundraise amongst themselves, and go towards ensuring that each and every family had a mabati house. And we were able to do so many. We would put the women together, we would encourage them, and then would link them with other NGOs for purposes of being funded. And that is a project that I'm still very proud of. And it is something that made me know that teamwork, you can be able to do a lot. Another issue that I did while in Eldoret was not really joining Maendeleo Wanawake. Maendeleo Wanawake for us, especially from the rural areas, was everything in terms of women and children, girl child. So in Eldoret, I now started to fully participate in the activities. And as you're talking right now, we've really been able to do a lot for the women in the village, encouraging them economically, socially, and even the issue that keeps on coming about FGM. Maendeleo ya Wanawake has really been able to do a lot, and especially from those regions where it's been prevalent for so many years. I think is a well-known issue, it's not a secret, that Elgeyo Marakwet at one time was considered the bedrock of FGM. But Maendeleo ya Wanawake, courtesy of the women who stood up, I included, went down and taught our women, our children, including our fathers, our brothers, that is a rite of passage that should be done away with. And right now, I'm happy to say that through those kind of initiatives like Maendeleo ya Wanawake, we've been able to do a lot. We even went as far as doing something that later we thought we should actually be able to sell to other places where FGM is very rampant. We came up courtesy of Dr. Susan Chebet, Moi University. She did a research on how is it that we can move, not only moving abruptly from FGM because there was lots of resistance. How is it that we massage the egos of these men who are insisting that these girls must go through FGM, of these women who think that without FGM they are not women? How do you massage their egos to feel, yes, we must do away with this thing, yet we don't do it in such a way that they go under the ground and still continue with the vice? The group came up with a project called Tumdonelero, and that project has really done wonders, wherein the girls don't go for the physical cut. What happens is when the schools close, the girls come all over from wherever they come from, their respective villages. They go into a school and they are taught modern way of doing things, hygiene, advice, hard work, how do you become a professor, that kind of thing. And it has worked wonders. And we are happy that Maendeleo not only has been able to economically empower the women on the ground, it has also done that.
Let me maybe refocus a little bit, Council.
Yes.
How have those experiences informed your decision to become CJ? That was the original question. What informed your decision to apply for the CJ job?
Thank you very much. When I look at it, really, when I was applying for this job, I looked at myself and I asked myself, Alice, do you think you can be able to do this job? And the answer was yes. Why? I have the steam. I'm a hard worker. And I love to serve the public. And I was telling you, I give you the example of Maendeleo ya Wanawake. It is a matter of giving to the society. After all, we got from the society. How do I replicate that and make it even in a better way? So I thought by joining or applying for the position of CJ would be able to foster that one much more. I've told you how I opened this school, and I was not yet through because at one point I was called, before I came to do the work of the Constitution. The Constitution we have is a precursor of the Bomas Constitution, which is famously referred to as the Yash Pal Guy's Constitution. Before I came to Nairobi to do the Constitution also, I was with Moi University Pension Scheme, and we were able to do a lot. No, sorry, it's the other way around. I came to Nairobi, I applied for the job to be one of the commissioners CKRC. I was taken in, and at that particular time, there was a lot of, it was around 2000. We were taken in 2000, but before that, we had a lot of problems in this country, political upheavals, and what came out from the people is we must have a constitution. So at that particular time, they advertised for that position. I applied for it, and we were taken in. We were from the Parliamentary Selection Committee group, that is through Parliament process. But we had another initiative from the civil society. And that initiative from the civil society came in a bit later, because there was some bit of undercurrent that the others from the civil society should not join the mainstream, in quotes, mainstream ones from Parliament. And when we were put in, there was a lot of friction because we came from different divides. We were viewed as from the parliamentary side, and then the others came in from the civil society, and somehow we were not able to bond very well the first time. But thank God, out of our own initiatives, sitting, talking to each other, having a cup of tea, we were able to bond and to move and do the work of the commission. Chairperson, we had a major problem. In fact, we wasted almost 2 to 3 months squabbling in the commission. But luckily, after lots of deliberations and reminding ourselves the mandate for which we came into this review process, that is to deliver a constitution to Kenyans, we said, let's leave aside all our shenanigans, all our problems, let's come together and forge ahead and give a constitution to the people of Kenya. When I say that I think and I believe that I'm able to do the work of a Chief Justice, is when I look at what really, or the perception I hear bedevils here, I imagine the issue of teamwork, because if we could be able to team up, and that was very, very difficult, then we should be able to move ahead and ensure that Kenyans have the best from the judiciary. I also worked for Elgeyo Marakwet County. That was in 2013. Just before that, I also worked in the task force, aligning the new constitution to the higher education. And our core mandate was, how do we have a feel of the universities and also of TVETs on the ground, that is under the devolved units? Was it possible to devolve also higher education and TVETs? For which our answer was yes, and we came up with a team that took over the work and to ensure and implement our findings that maybe you should have had universities also or TVETs also in the devolved level of government. Yes, also I was one of the council members, Taita Taveta University, in its infancy. I was made a council member, and within, I think it was within a week, report to Boy. We want you and your team to go and set up Taita Taveta University. And we went there, we found, yes, there was a teachers' college, teachers' training college, and we came up with a plan on how we were going to set it up. And by the time I left, though I left after a short while, it was on its own feet and running. Thereafter, I joined politics, 2013, finished with it, came back, went back, that is, I went to, thereafter I joined Elgeyo Marakwet County. And that is a pet subject, because what made me join Elgeyo Marakwet County? Because somebody was asking me a very loud question about that. The salary was paltry, 109,000. Subjected to taxation, take home was 89. So somebody asked me, really, Yano, you leave your business, lucrative business in Nairobi to go to the county. But the informing factor was we wanted to go and strengthen the county by coming up with laws. So we came up as a team. We got a doctor from Elgeyo Marakwet. We got a professor from Elgeyo Marakwet to be in charge of education. I went there to be in charge of the legal part. We had an agriculturalist, about 6 of us. So we left Nairobi and we went to the county. And I was able to do my part. And as we are talking right now, it's not a secret. Elgeyo Marakwet have the best county laws, and it is leading in county laws, courtesy of getting out of this place to go and help your county grow. And I'm very proud of that. So as of now, I'm running Yano and Company Advocate. And to tie that to the question you've asked me, from the experience I've given you, Madam Chair, is I'm a person who goes for it. I'm a go-getter. I'm a very courageous lady. And to add on to that, I give out. I like sharing out. I don't get and keep it to myself. I'd want others to benefit from my own experience. And that's why I was able to explain to you from the beginning what I've been doing to date.
Okay, Council, let's move on to the second question. When you talk to the stakeholders about the kind of CJ they would want, they say that they want a transformative leader who can lead the judiciary. They also say that they want a leader, a CJ, who can also lead in jurisprudence. So please demonstrate to the Commission that you are this leader, both transformative and also a leader who can lead your colleagues in the development of jurisprudence.
Thank you very much, Madam Chair. Yes, on transformation, first of all, I would want to thank the teams that have been there from 2011 to date, because they have done transformation, that is, they came up with the JTF. They've done also sustaining judicial transformation. And when I looked over the documentation, I found that a lot had been done. As a transformative leader, what I believe in is to work on what is there. And I want to look at it from an example. I look at it from where it started, where it is, and what is it I can bring in. And I want to bring in an analogy there to say, look.
And Council, once more,
yes,
I'm discouraging you from referring to any notes. Just talk to the Commission. Maybe you can keep the notes aside.
Actually, I was writing the question. I'm not referring to any notes.
Okay, thank you. All right, just talk to us.
Yes, I want to look at it from, I want to give an example. What comes to my mind is, here is a patient that was before the promulgation of the Constitution. And here is the team that has just come into the judiciary, and they find a patient, because there's no hidden secret that before the promulgation of the Constitution, we were in a very bad state in terms of judiciary. So this team comes in, they find a patient, And they diagnosed this patient. What is ailing this patient? And it came out clearly that this patient was sick, and what was ailing the patient is A, B, C, D. Lacked finances, maybe human resource was not adequate or did not have full capacity. ICT was not well developed, issues of backlog of cases. And after diagnosing, they said, yes, how do we treat this patient? What is the medicine? And they brought in medicine, started fundraising and asking for more money from the consolidated fund to ensure they plug in part issues of finances, getting IMF to assist in putting up infrastructure. Issue of, they came up with the issue of human resource, training, making use of the JTI, and I think also there must have been some benchmarking. Then come ICT. Also, they brought in issues of ICT. I can see Milimani. We have the gadgets there, and I know Supreme Court is fully functional. And then saw how best they could do away with the backlog of cases. I'm just giving examples, Madam Chair. So they've seen the patient has all these, and they've tried to met some treatment onto the patient. SJT came in also, and they built on this and strengthened and ensured the patient is getting better by going for further funds, fundraising further, also training their staff, seeing how best can we do away with backlog of cases. And in fact, one of them that came out very clearly the other day, and I'm so happy about, is court annexed mediation, which is really assisting in clearing of the backlog of cases. And also working on ICT. Right now we have e-filing. We can pay through, we can pay electronically and all that. So they've really tried to sustain. Now, when I come in as part of this transformation, yes, sustaining will still be there. But what will Alice Yano bring in case I became a CJ? There is what usually comes to my mind when I look at all this. In as much as we are sustaining, also the kind of treatment we are giving could be causing more problems than it's solving. Or the kind of treatment, we are giving treatment, but then there are other opportunistic problems that come out of it, opportunistic diseases. And I was looking at it and I said, some of these things can just be corrected within a short time, may not even take long. When I look at ICT, in as much as it is fully dependent on financial, that is to be made, to be funded heavily. But from what is there right now, that can be solved even very quickly. I'm sorry to say this, Chairperson, because also at times I say to the members of staff, we all of us come from a mixed group, and you get to hear what they say. There is that fear of loss of jobs. Some of them say, look, fine, if ICT becomes optimum, what will happen to our jobs? So there is a resistance somewhere. Some of them could be resisting, though I'm not saying they're resisting. I'm saying some of them could be resisting. Is there an assurance that the members or the staff can be assured that you can as well be trained in the same field or even transferred to another field and you're still able to work for the judiciary and also able to ensure that the judiciary moves towards achieving its core business? Finances, yes, I can say a lot has been done. But then what I was saying also is there a possibility that we can be able to ensure that if there is an amount that has been slotted for the judiciary, we get it in full. So as in there's any budgetary provisions that have been put in place, they're not disrupted. When also it comes to issues of finances, is there a way also of expanding and moving out from the usual donors? Are there any other donors that can be approached? But in this case also independence must be key. And if it is infrastructure, I know some of the counties been giving out land for purposes of constructing law courts. Can we still pursue that? So there are so many things that can be done to strengthen what the SJT has been doing. And I will not stop there. There are so many, because when I look at issues of backlog of cases, Chair, backlog of cases to me mostly, yes, it is real. But how do we solve it? These are patients now we are sustaining. We've been trying to solve these cases, case backlog, by getting more judges, getting more judicial officers, maybe getting more staff. Is there a way that we can be able to move also ahead and apply other alternative dispute resolution mechanisms to ensure we reduce on the backlog? Is there a way also?
Council, I thought we have those other alternatives, or you mean more? Addition?
Yes, yes, that's why I want to give an example.
Okay.
My chairperson. From where I come from, I do practice in Kajiado County. Thank you, and I'm grateful for the team that came up with NCAJ, because CUCs are very active in Kajiado County. That one I must say, because usually, and it has really helped in a way in reducing the backlog of cases in a very simple way. If there is a boundary dispute, in most cases, we are told as parties, is there a way you can talk amongst each other, include members of the CUC, go to the ground, go and look at what could be the problem on the ground. And you'll find you'll get the chief there, you'll get the headman there, you'll get some, how do I call, Numbakumi people there, and they'll sit and they'll say, yes, look, we may not seriously have a problem. The problem is our neighbor here feels that because he works somewhere and is very rich, he can come and bring us problems. So it's like, was there really a serious dispute, boundary dispute problem? No, it's ego. It's like you want to behave that you're tough, even as we're showing you we are tough. That is an example I'm giving. The other issue also is, apart from CUCs, and I want to look also, I give an example of Elgeyo Marakwet. And this is a very interesting example, Chair. I think there's some paper that has been written on it, though I don't think it has circulated widely. Marakwet have a very special way of dealing with murder cases. I say this, though I would not want to contradict the issue that maybe customary law could go against written law. If a Marakwet committed murder, what happens is it will behove upon the family or the uncles, that is where the mother came from, to pay, to restitute the family that lost their person. And what they do is they count bone by bone, like if it is the index finger, we have 3 bones, 1, 2, 3. So they count all the bones in the body. And they come to the family where the mother came from, and these are the bones of our deceased person, pairs those bones in terms of cattle. And what happens is, if they paid, that is long time ago now, if they paid, what would happen is they clear with it, and the person is let to go free. But at the advent of the written law, yes, murder is committed. This person is taken to court. Fortunately, if he comes out, the same procedure will still apply to him. They have the mothers, where the mother's family must be able to pay cows equivalent to the bones in the body of that person. What does that one tell us? It is a deterrence. At the end of the day, these people usually live very well, and I cannot say I've heard of any murder case for a long time. Because when you're told you're going to pay cows equivalent to each and every bone in the body, you'll run away. You'll not want to repeat that.
Okay, I think I'll stop there, but there's something you didn't answer, and I really don't want to leave it. If you become CJ counsel,
yes,
you'll also be the president of the Supreme Court, and in which case you'll be required to give leadership, as I said earlier, in the development of jurisprudence. So how, you didn't demonstrate to us, counsel, how you can do this, how you're going to work with your colleagues. Just 1 minute,
yes,
then we can move on.
Yes, I remember, Chair. Sorry, that was actually the second limb of your question. Yes, Supreme Court, if I become the Chief Justice Chair, I know Supreme Court works in tandem in a collegial manner, such that whatever judgments or rulings they come up with, in most cases, they would have had a conference and looked at the same, whether they agree on it or not, then parties can be able, if one of them has not or two of them have not agreed on the decision, they can give out their reasons why they've not agreed. When I become the Chief Justice, one of the most important tasks is to create jurisprudence, but of course not creating jurisprudence as Alice Yano alone. When matters come before the Supreme Court, we must sit together as judges of the Supreme Court and look at it, do critical thinking, come up with a way forward and a judgment that does only look good to the Supreme Court, because it will be binding upon the other courts, must come up with a judgment that will make sure that flows to ensure development of the law.
Okay, thank you very much. And now I'll request Acting CJ to continue the technical questions.
Thank you. Counsel, what do you know to be the functions of the Office of the Judiciary Ombudsman? And as Chief Justice, what are you going to do to enhance what it does?
Yes, thank you very much, my lady. Yes, the chief function of the Ombudsman, Judiciary Ombudsman, is to receive complaints from the public and see how best to solve those complaints. As the issue of strengthening the Ombudsman, the best that can be done first is evaluation, because I really don't know how it handles these matters. But from the public there, really, we've not had so many complaints about it. So I don't know how it's being handled now, but to me, strengthening will mean maybe in terms of human resource.
Counsel, if you don't know what it does, then you really can't know how.
I know, sorry, my lady, I know what it does. I've already explained to you what it does.
I'm using your words, but we could make a little progress.
Yes.
Do you know what role it plays in the judiciary transformation?
Yes. The role it plays in judiciary transformation is, my lady, you see, outside there, we have so many complaints, whether true or perceived. And these complaints have really had an impact on the workings of the judiciary, such that, the judiciary is made to look like it does not work, it does not do what, so many complaints that could be there or not there. But to me, really, because I'm a consumer of the legal services of the judiciary, I may not really have so much to say about whether I may not say that it has not delivered because I'm a consumer. If a member of the public has such an issue that really bothers him or her, the best that member of the public is to go to the Ombudsman. And the Ombudsman from there will take over that matter, look at the merits and demerits, and it should be able to assuage that member of the public that that problem is either something to be followed up or it rests there. And that way, the Ombudsman's office would have given lots of confidence to the members of the public that really we are taken care of in the judiciary.
Thank you, Counsel. The Office of the Judiciary Ombudsman does more than just look at complaints. Maybe Counsel could look at that at a later date. Information and communication technology, Counsel will agree, is seen as a key realization of the strategies and strategic direction the judiciary wishes to take. Would Counsel please name specific proposals on how Counsel would enhance our current position as Chief Justice?
Please, my DCJ, kindly repeat the question.
I'll do it again.
Yes.
What is the role of ICT in the strategic direction of the judiciary, and how would Counsel, if she became Chief Justice, deal with the issue of ICT in the judiciary? With directed answers, kindly.
Yes, the role of ICT in judiciary is actually to make the work easy for the judiciary. Once we have electronic transmission of court proceedings, electronic storage of all court documentations, proceedings, judgments, rulings, and all that, electronic filing, electronic, we have now filing, we have even paying the court fees and all that. The role of ICT in judiciary is insurmountable. It is very, very important, because then it lessens the workload by virtue of reducing time taken to write. It also lessens financial obligations, because when we use the paperwork and all that, it's so expensive. And also the role of ICT also in the judiciary brings in, and I see it is working very well, it brings in some sense of confidentiality and trust between the judiciary and members of the public. Why do I say so? Because then there isn't a lot of physical interaction between litigants, advocates, general members of the public with the judiciary officers. So that notion, that feeling of, may I give an example, that issue that comes up that maybe judicial staff are bribed may not come up at all, because now if the money goes electronically, where does this staff come in for purposes of that perception of being bribed comes from?
Allow me to redirect counsel to answering the question on what counsel would do if you became the Chief Justice to prioritize. We have identified it as a key objective of our strategic plan. You will find it at that stage. So as Chief Justice, how would you take it forward as a priority?
Thank you very much, my lady. In fact, true, very true. It is a real priority right now. Not only because of COVID, the world has gone there. And there is no way we'll ever come back to the way we've been doing things manual. How do I prioritize it? Yes, I think the major thing that we have, actually the major problem that we have is issue of funding, finances, to fund ICT, whether in terms of the real gadgets, the machines, or training, or training so that members of the judiciary, and not only the judiciary, also the consumers of the services should also be informed that it's very important we are going ICT. So the priority that I'm looking at is, from the part of funding, what is it? What is the opportunity cost that we can apply? What is it that we can do away with for the time being to strengthen ICT? For me, I would say that maybe we can stay some structures, that is court buildings, because I know there's been a very concerted effort to put up courts all over the counties, and I'm very happy because I think there are very few counties that are remaining without the courts. Maybe we can look at it in such a way that, yes, we may continue with construction of the county offices, but let us reduce a bit, let us cut down a bit on what goes to those structures and bring it towards prioritizing ICT.
Thank you, Counsel. What do you know to be the role of leadership management teams in the judiciary? What is their role? And what challenges do they face to your knowledge? And how are you to improve them as Chief Justice and solve the problems?
Yes, thank you very much. Yes, management in the judiciary is key, and I know very well that there are teams that have been created to ensure that the core business of the judiciary is served. When I look at teams in the judiciary, I look at the teams that, like JLAC, that is the advisor.
Counsel, let's do this, sir.
Yes.
Please tell us the membership of our leadership management teams at court stations.
Leadership? Sorry.
That team we call LMT. It's the leadership management team, and they are at each level of court It's not the advisory committee to the Chief Justice. These are at court level. So my initial and first question was whether you know what they are and the role they play. So maybe you could answer that directly.
Yes, thank you very much, my lady. I may not describe LMT as such, but once you've guided me to say that they are at each and every level of the judiciary, then what comes to my mind is the level at the Supreme Court, the level at the Court of Appeal, the High Court.
Counsel, as a matter of fact, do you know the existence of the LMTs? Because if you don't, we go to another issue.
I may say I'm not really aware of that.
Thank you.
Yes.
You said something about CUCs earlier when you were engaging with our chair, but without the details you gave earlier, can you tell us the specific roles played by CUC?
Thank you very much, my lady. Yes, CUCs is a product of NCAJ. By virtue of being a product of NCAJ and looking at the composition of NCAJ, it is a stakeholders body.
I said functions, Counsel.
Yes, I'm coming there, my lady.
Okay.
I'm coming there, my lady. Thank you very much for
Okay.
Yes. And when you look at the composition of NCAJ, we have all the stakeholders that can be able to come together and bring in issues of or assist in administration of justice. So CUC is on the ground level, and it has almost carried the same membership of NCAJ to the lower level. And the main function that I know of, and especially from my experience, is helping in the administration of justice, because like on the ground, you have, I can just give an example, you have an OCS. An OCS must ensure that those ones who are in police custody are delivered on time to court to take place. That's an example I'm giving. You also find that on the ground we'll have prisons officer, and they are the ones who will be able to bring remandees on time to court. So the core function of CUC is to help in administration of justice so that we can have cohesiveness.
Thank you, Counsel. The 2005 final CKRC report, which you signed, interestingly recommended the establishment of village elders tribunals to hear and determine land disputes, and hear and determine matters of personal law. But you want to tell us the rationale for that recommendation? And then after you've done that, can you tell us what the judiciary has done that is akin to that situation since the 2010 Constitution?
Yes. The precursor to this CKRC, sorry, we call it a draft, the 2005 draft, was after collecting views from all over the country. We went as far as Turkana, Wajir, wherever. We even came, I remember we were even outside here, we came here to take the views of the judiciary. And when we sat down to collate the views, after collecting and all that, we collected the views. What came as one of the major issues of dispute resolution. Actually, this is mostly part of what we wanted we wanted to have it as part of dispute resolution. Was in the villages mostly, and that is where we find the majority of the consumers of justice. In the villages, there are so many ways that they can do their own disputes in terms of regulating their own affairs, including land and also personal laws. And I had mentioned earlier how even they could be able to regulate boundaries. They still do it. I know of some groups that do it. So the land dispute tribunals, we've been having them, I think, for a long, long time. We've been having them in our legislation. Yes, we used to have it. I'm not so sure right now. In a way, it involved the provincial administration then, and maybe some women representatives. We say public, they could pick some members of the public, and they will sit down and agree on how disputes on land were going to be dealt with. But yes, I think it's been done away with, because after that, I think that is the second limb of your question, my lady, is that we have ELC, which has the mandate to do all these irrespective. On the second limb of personal law, how we arrived at that, it was very pertinent that some communities wanted to do their own things differently, as long as the rider it's not repugnant to justice and morality, and it's not against the written law. And we were able to come up, like even, for example, what we have even right now in our constitution, we were able to come up with Curtis courts. I remember there was a lot of fightings, those ones of why should we have it. But generally we agreed and we said, here, there's no problem. This is personal law. If they have their own way of solving it, so let it be. Let them solve their own personal laws, that is marriage, divorce, I think also inheritance. Can we leave it to them? Yes.
Okay. Are you done? Sorry.
It's okay. It's okay.
All right. Inside the judiciary, we have something called the alternative justice system. Would you know what that is?
Yes, I do. Oh, my lady.
Counsel, please tell us what it is and how it works here, the role it plays, please.
Thank you very much, my lady. First, I must start by congratulating you, because I didn't know that it had come into fruition. Sometimes back, I think it was being debated upon quite a lot. Alternative sorry, was it AJS?
Yes.
I think it is to do with encouraging communities and members of our holistic society to try as much as possible to solve disputes using their own traditional way or customary methods, as long as it does not go against the norms of what I've been saying. That is not repugnant, it's not against the written law. And I believe if that is what has come up, then the backlog of case backlog will really go down.
Have you seen our policy on AJS?
No, I've not seen it, my lady.
All right, we launched it just the other day.
Thank you.
Do you know the difference between AJS and ADR?
Yes. I may talk very well about ADR because it's more or less structured. We have arbitration, we have mediation, we have negotiation. But then when it comes to AJS, since I've not seen your policy, my lady, I may not really want to say so much about it.
All right. And I understand, and you're quite right there. But let's go to something else. As Chief Justice, Counsel, you would be our team leader, and the link between us and other organs of state, including county governments. Now, you told us earlier that you are a county attorney?
Yes.
Good. Now, what did you acquire there that would enhance your link between us and the county governments? Let's just remain with the county governments.
Okay. The link, my lady, is very well pronounced, not only in the Constitution, but also in the legislation. It's very important. I mean, the judiciary cannot live as an island on its own. It must be able to interact with the other links, whether it's the links of the government or the way also you've told me, your lady, that also with the links in the county government. The link is very important because let's say judiciary on its own cannot stand on its own without being with the others. And if that one happens, then it is bound to fail. It's very, very important. Only that the overriding factor, my lady, is independence of the judiciary must be safeguarded altogether. But does not mean that when you link with the other arms of government or also the county government, then that independence is eroded.
We counsel know we are still on the same thing, so yes. Whatever you wanted to say now, you can continue saying. But we're looking for your knowledge of what we have done with county governments,
yes,
administratively to support them, and what they have done themselves to enhance the performance of the judiciary in access to justice, because that's our core mandate.
Most obliged. Thank you, my lady. What came into my mind, definitely, that is the first thing is I remember there was a circular that county governments should be able to provide at least land for purposes of enabling the judiciary to put up structures, court structures. And that was a good gesture, and I know most of the counties, including also Elgeyo Marakwet, as I'm speaking right now, has already ceded out land to the judiciary so that it can be able to build structures. And the other thing that also came to my mind sometimes back is once the county government has ceded out land to the judiciary, it will also be upon the county attorney of that county and also the judiciary legal team to ensure that that property is registered under Judicial Service Commission, so that we don't have a situation where maybe with the time, if there are any altercations, it will be, the judiciary, the judicial officers in the locals might be kicked out. So that is also another very important part. Apart from ceding out land, also ensuring documentations are properly done. That will be a very important link. And the other one, my lady, is communication is key. Even this perception we have in the judiciary as maybe we don't work, or that is as judiciary, that judiciary does not work optimally. the backlog, the bad name that comes here. We could use that channel because the county governments have a very good channel of communication. Communication not only in the sense of holding barazas, but also, disseminating issues from the county to the ward level, to the sub-ward level, all the way to the village. So you will find even the common mwananchi in the village there would know what judiciary is doing if the judiciary can be able to take advantage of that communication system that disseminates to the people on the ground.
Thank you, Counsel. If you come in here as Chief Justice, you would automatically be the President of the Supreme Court. One of your leading roles there is to lead as the jurisprudential head of the entire institution. And therefore, in respect of jurisprudence, we would not get a better person than the Chief Justice. You will find 6 co-equal judges as far as jurisprudence is concerned, and you will be the team leader. Please explain to us what you see, listen to my question, as the role of a dissent judgment in a collegial court such as the Supreme Court.
Yes, thank you very much, my lady. Yes, as I'd said earlier, as President of the Supreme Court, being the Chief Justice, a Chief Justice is first among equal. When it comes to decision making, the Chief Justice is not at a higher rank than the others. So what does it call for? It calls for honest, fair decision making amongst all the sitting members of the Supreme Court at that particular time. And once they have, before even they can concretize their own decision making, maybe they will call for a conference and discuss issues.
Sorry, let us remain with the issue. The issue is your view on dissent judgments from a collegial court.
Yes, ma'am.
There's something we are looking for.
Yes. So, my lady, once they've agreed and there is a dissent from one of the judges, then of course the same is recorded. And it is very important because this is part of building jurisprudence. Dissent does not mean that you're not happy with what your colleagues have done. You also, this other judge is coming up with how they feel and think this matter should have been adjudicated upon. So for me, it is very clear that even this dissent maybe in future could be the reigning or could become reference point towards achieving better jurisprudence, because society is dynamic. They could be, the dissent of today may not be the dissent of tomorrow. It could actually be the precedent of tomorrow.
Thank you.
Yes.
We've had critique of the Supreme Court as being the court that has created for itself unlimited appellate jurisdiction, unlimited appellate jurisdiction. What would counsel say about that critique? Is it in fact a critique or a criticism? And what is the truth or otherwise of the original statement?
Yes, my lady, I think also this one is a matter of discussion and conjecture. Because when I look at that, what comes to my mind immediately, some case that the ones who criticize what the Supreme Court did are saying that there should be an end to litigation at some point. I think this is a neutral case, though I've glossed over it. I was not part of it. And from what I followed from that case is Section 35 of the Arbitration Act. I mean, towards bringing an end to litigation must end at the High Court. But after the High Court, the matter ended at the Supreme Court. So,
is counsel saying that the Supreme Court had no jurisdiction to hear neutral?
No, my lady, I'm coming from the point that you asked me about the criticism and all that. That is what came out. But I'm not saying that neutral case was a bad decided case. No, I'm just mentioning.
And that's not the issue.
Yes.
I think we must stand guided. You have said something about Section 35. The question is arising from what counsel has just mentioned now, is whether the Supreme Court in fact had jurisdiction to hear the issues raised in U2.
My answer would be definitely yes.
Because we're talking about unlimited appellate jurisdiction. That's what we are addressing right now.
Yes, you had the right, because can I explain further?
Yes, of course.
Yes.
Of course.
Because on issues of interpretation of the Constitution and issues of general public, then it has jurisdiction to hear those matters.
Yeah,
so for me, yes.
No, you're quite right there, but the issue is we have this category of justice consumers. The one part says this court has created for itself unlimited appellate jurisdiction. Now, we are asking you not so much your view as to whether that statement is indeed correct, but where it comes from. Any person who says that, what would be bothering them?
I actually don't think that the Supreme Court does not have that unlimited appellate jurisdiction. It does. And to answer it shortly, my mind comes to what would it be that may want other or may call for criticism. It is a sense that when we look at, sorry to go back to arbitration, my lady, when you look at that arbitration issue, it's like this is a commercial dispute. If it's a commercial dispute, maybe parties would want to clear with it, finish with it, and move on and do other things. But when now the critics or criticism that I hear from that is by taking it all the way to the Supreme Court could be time consuming and waste of money. And that is where I come from, not that I'm saying or I would agree with those criticisms.
Thank you, counsel. Let's put the question differently. What is the jurisdiction of the Supreme Court?
Yes, the main ones are to hear or to hear petitions, presidential petitions, which is the original jurisdiction. Secondly, to hear appeals on interpretation of the Constitution, and matters, issues touching on matters of public importance. The other one also is to hear, apart from petitions, I think that one, yes, when I say apart from the petitions, that is matters of public importance, interpretation of the Constitution, and also to hear appeals from the High Court.
Thank you, Counsel.
Yes.
Back to you, Chair.
Thank you very much, Commissioner Acting CJ. Thank you very much, Counsel. And now we go to Honorable Commissioner Judge Wasame to continue the questions. Judge, please.
Thank you, Professor. Counsel, from your CV, you said you have worked with the county, you have been a county attorney for Elgeyo Marakwet.
Yes, my lord.
And you have dealt with a lot of legislations, as you said.
Yes, my lord.
The biggest threat to devolution is the county assemblies.
Yes, my lord.
And the way they undertake impeachment of governors.
Yes.
Tell us two ways in terms of legislation proposals you will give governors or the Council of Governors to insulate them from this persistent and consistent impeachment motions filed.
Yes, it's true, my lord. County assemblies have been the guillotine houses for most of the governors. One of them is on the issue of accountability by the county governments also. I think a legislation should come up wherein the county governments are made to be accountable for the money they're using the county assemblies are made to be accountable to the money they're using in the county assemblies. That's very important because that will make them also know that in as much as they're watchdogs as against the county government, they should also be watched. I don't know whether they're getting each other. Yes.
You're there. Again, another problem I find in this impeachment, it talks about whenever a vacancy arises in the office of the governor through impeachment or the office of the president. For the office of the president, the deputy takes over for the remainder of the term. And for the office of the governor, the deputy governor. What is your view on that constitutional provision? The fact that, we have elected our president directly ourselves, we have not elected the deputy governors, and we are giving them fruits on the silver platter. Is it time to change that legislation?
My lord, that's a very emotive issue, and I think it's in the public outside there. The discussion is very live, and I'll be a bit uncomfortable giving my opinion on that.
Yes.
It's a very live discussion.
Yes.
Yes.
Again, under Article 193, a governor is not eligible for re-election. In terms of 193, for example, and I take this very important, 193(2), I think this is the one which deals with impeachment, has been found in accordance with any law to have misused or abused a state office or a public office or to have contravened Chapter 6 is not eligible, among other things. But the most critical aspect which I want you to address is this. which is 193.3, which says a person is not disqualified under clause 2 unless all possibility of appeal or review of the relevant sentence of the decision has been exhausted. Now, this is my question. For you to exhaust the appeal process, the review process, and to overturn the decision of the Senate, both as a sitting president and as a governor, there shouldn't be a situation whereby you are removed today, maybe at 11 p.m., and the following morning you find somebody in your office before you have exhausted the review process, the appeal process, and the sentence has not been set aside or confirmed, the decision. Now, is it time, because the Constitution is not clear, time for us to give governors maybe 14 days, maybe 30 days, to exhaust that appeal process or review process, either for the sentence to be, or the decision to be overturned or confirmed in terms of timelines of the impeachment process?
Yes, my Lord, I would want to answer it this way. Yeah, it's a very tedious process, and especially after the Senate, then to the court, and all that partakes to the point of having exhausted all the channels. My Lord, I think also that is the reason why these courts are really clogged with so many cases, because things don't seem to move as per what is provided for by the Constitution. I really did not get the second limb on how you crafted the question, my Lord.
I said, is it time for us to propose a legislation to give governors time within which to challenge the decision before somebody takes over their office after impeachment?
I think that would be natural justice, my Lord. That is given time, because you're saying that immediately after impeachment, let's talk about the deputy governor takes over.
Yes.
And then the governor had not exhausted the appeals, or had not even started the channel of appealing against the decision of the Senate.
Yes.
That it is a high time we give them time to exhaust those channels, and with a time limit.
Which means, if he cannot be disqualified from running for a second term, cannot be disqualified from running for a second time because he has exhausted the mechanisms provided under the Constitution, does it go without saying that he also does not lose his office within the first or second day of impeachment? Is there a timelines which we must provide? The fact that there is no timelines after impeachment.
I think so, my Lord. I think that is an issue where one has to really think deeply about it.
Okay.
Yes.
Again on impeachment, and if it's difficult, you don't need to answer. Under Article 145C, 1C, one of the grounds for removal of the President of the Republic is for gross misconduct. Under Article 181, 1C, which is also similar in terms, among other issues, is abuse of office or gross misconduct. For the President, the word abuse of office is not used under the Constitution. But for the governor, both the word is abuse of office or gross misconduct is used. Do you have any reasons for that? Or any proposals? Or your views?
I think abuse of office will call for a higher standard of proof. Gross misconduct maybe could be taken at almost face value as long as it can be proved that it was gross misconduct. That's my thinking about it.
Okay. There is a debate about whether a speaker or a governor is an employee. Therefore, the labor court has jurisdiction or has no jurisdiction. Are you aware of that debate?
No, I'm not aware of that.
You are not aware of that debate.
Yes.
Okay, so I will not ask you that. And this is my last question. If I tell you that the biggest threat to national security in our country is tribalism and or nepotism, 2, populating wrong people in a sensitive places, and thirdly, the way we conduct our elections in that priority, among others. And then other things follow. Would you agree?
Yes, I do.
Thank you very much. I wish you well.
Thank you, my lord.
Counsel, you don't want to elaborate a little bit?
Yes.
With what Judge Basame asked, or you're okay?
I'm okay, thank you.
Okay.
Yes.
Thank you very much, Counsel. It's now the time for Honorable Commissioner Judge Majaja to continue with the questions. Judge Majaja.
Thank you, Chair. Good morning once again, Council.
Good morning, my lord.
Part of my task is just to look at your sample writings. You presented 6 samples. One was a written submission in a land case at the Kajiado ELC. Second one was election petition Kajiado West, a submission for one of the respondents. The third submission was a running down case at the Kajiado Magistrates Court. Then you presented 2 submissions on a no case to answer in respect of the Magistrates Court, and another submission in opposition to an injunction application in a succession court in Nairobi. I must say that the submissions are clear, well written, and I will ask you questions related to not necessarily on the subject of the case, but technical issues surrounding what you have written and from your own experience as set out in your CV in relation to the work you do. First, I just want to follow up from what my colleague, the Chief Justice, Deputy Chief Justice, asked you about the Supreme Court. That's an important court. Have you had a chance to read the strategic plan?
No, I've not had a chance to read the
You have not had a
yes.
chance to read
Yes.
the strategic plan. Have you read the Judiciary strategic plan?
I've glossed over it.
You glossed over it.
Yes.
Okay, but you worked in management positions before?
Yes, I've done so.
Okay,
Yes.
so just tell us very briefly what you understand by the term knowledge management, and how it relates to the work of the Supreme Court.
Yes. Thank you very much, my lord. Yes, knowledge management to me literally means you must, like if it has to do with Supreme Court, you must have sound legal understanding of issues in terms of knowledge, in terms of reading, maybe in terms of paperwork and all that, so that you can be able to apply the same in upcoming cases that may be brought before you.
Okay, thank you. You were involved in the constitutional making process.
Yes.
As one of the commissioners. So probably you can tell us what is the doctrine of judicial deference, the doctrine of judicial deference, and in telling us what it is, probably would give us an example from decided cases in the High Court, Court of Appeal, or Supreme Court, and what is its constitutional basis. The doctrine of judicial deference as it applies to the Constitution, and any examples of that deference from decided cases within this jurisdiction.
Maybe, Your Honor, sorry, my Lord, you can give a guidance a bit on what...
Okay,
yes.
What do you understand? What do you mean by defer? If a court says it is deferring to another institution, what is that? Well, let me put it this way.
Yes.
A court can say that because this subject matter is being dealt with by another institution, we will not deal with the issue. Basically, I'm giving you the answer. That is called judicial deference.
Yes.
So the court may say, we are not dealing with this matter because there's another institution.
Thank you.
So having given you that answer, can you tell me what is the constitutional basis of that kind of doctrine, and whether you know of any cases that it has been applied either in the Supreme Court, Court of Appeal, or High Court?
Yes. What comes to my mind, if I get that very well, is where, I don't know whether it was in the Supreme Court, but I remember a ruling that was given by the court. The court said, we may not want to deal with this matter as it is before us right now, because the same can be dealt with elsewhere. It was a political issue. I think it dealt with nomination of members to a political party, and the court put its hands up and said, no, you go to the political parties tribunal. I remember there was a matter of that.
So on what basis, what constitutional basis is that kind of doctrine founded on? And why do you think it is important sometimes for the court to defer?
Could it be separation of powers?
Okay. Let me go to the next question. Again, this is from your position at the Constitutional Review Commission. The Supreme Court occupies a very important role in the hierarchy of the courts in constitutional cases. There is a phrase in section 259(3) of the Constitution that says, in interpreting this Constitution, every provision of the Constitution shall be construed according to the interpretation that the law is always speaking. That the law is always speaking. What do you understand by that term in terms of constitutional interpretation?
Yes. When interpreting the Constitution, you look at it from a very holistic approach. And the holistic approach is the doctrines that the makers of the Constitution and the people wanted the Constitution to be made, that is Wanjiku, wanted the Constitution to safeguard, so that it brings issues of values, integrity, impartiality, equality, and all that, so that as you're interpreting the Constitution, you look at it from all those global areas to give it a living, to be a living, not only in paper, to be alive to the needs of the people.
Can you give us one case that demonstrates that principle you're saying, one decided case of the Supreme Court?
And that one, I can also give the case of Murwatetu. Because then, when the Supreme Court ruled that the judges or the magistrate's hands should not be fettered in terms of their own discretion, then it was giving effect to the fact that once a matter has appeared before a judge or a magistrate, then they can use their discretion in terms of sentencing. And I think it captured the values of that interpretation and also the dynamism of the society. We are dynamic and we're moving on.
Yes. Now that you have mentioned the Muruatetu case, which I'm sure if you have been watching the interviews has been really the subject of discussion, can you tell us what specific constitutional provisions or doctrines that the court are used to arrive at that conclusion you are talking about?
Please, may I
Yes.
get the question again, my lord?
You have said what the Muruatetu decided, that it gave magistrates discretion. Of course, that was on the basis of certain provisions of the Constitution.
Yes.
So can you tell us what provisions of the Constitution are these the court interpreted to enable it reach that conclusion which you have talked about?
Oh, yes. I think basing on the fact that the Constitution per se does not provide for a death sentence, and here we have the Penal Code, was it Section 204, providing for the death sentence, and also the other issue is once a judicial officer, a magistrate or a judge would have gone, if we look at the issue of discretion, what happens when it reaches the point of sentencing? What is it that mitigation in sentencing, what will it help once the sentence is mandatory death sentence? So then it takes away the powers of the magistrate or the judge from really looking at what these magistrates could have been able to do with the mitigation. Another point also touching on that is different circumstances may be looked at, because yes, we can have the penalty saying death sentence is, mandatory death sentence is, for murder, mandatory sentence is death. But
Counsel, maybe just to redirect you, my question was specific. The court, the reason why the matter reached the Supreme Court is because it raised constitutional issues. So I was asking, what is this? Tell us just one provision of the Constitution that the court was expounding in order to reach the conclusions which you are talking about.
yes,
Just one provision.
Okay, provides that justice should be arrived at from looking at issues and arriving at it fairly and equitably, depending on the facts of the case.
Okay. Is there a specific article of the Constitution that deals with that particular aspect?
I may not mention the specific article, but I know in my mind.
Which substance? What is the substance of that article? If we don't know, say the number, maybe the substance of that article that says the court should do what it's saying it's doing. Article on fair trial?
Yes,
perhaps?
article on fair trial.
Okay.
Yes.
Let me move on to another substance of another experience which you have had.
Yeah.
You were a member on alignment of higher education to the Constitution.
Yes.
Which means, and I guess you familiarized yourself with the education system. you looked before you, I mean, if you are looking at higher education, you looked at the education system, so you understand some of the issues that we deal with, and you are a parent also, isn't it? So, the question I want to ask, to Article 27 of the Constitution, which is a pivotal provision, talks about equality and freedom from discrimination. That is an article I'm sure you're very familiar with. Yes. So I want to ask you, we have just completed KCSE, and government has a policy of restricting the number of pupils from private primary schools who can join national public secondary schools. Am I right?
Yes.
Yes. So how is that provision justified in light of Article 27? Can you just elucidate to us?
Yes. I think what the government actually is doing is to ensure there is fair access to education for all. And fair access to education for all is looking at, and if I take you back, my lord, to what we did in the task force, is like we were looking at these regions that they may have had not even TVETs. And the propelling factor was, let us ensure that we have colleges, that is universities, TVETs, to be put up in these regions, so that we bring the issue of we do away with the issue of feeling that others are marginalized. So that is where we're coming from, that to expose diversity, let us move also the universities to other regions other than having them concentrated in areas that were well known to be concentrated. And when you raise this issue of education, my mind is very clear. It's still the same issue of diversity. Can we have almost an equal sense of education to each and every child?
So what is the term used in Article 27 for that kind of intervention?
Can I maybe look at the Constitution, my lord?
Well, the answer is there. Maybe look at it. It is called affirmative action. So I'll move on to the next question. You have, in one of the cases you provided for us, in one of the cases was an election petition, Kajiado West. And from the jurisprudence of this, in fact, I would say, if you look at all the reported cases of the Supreme Court, a third of them are to do with election petitions, isn't it? A third from the time inception. The question I want to ask is, one, does the Supreme Court have jurisdiction to deal with a third appeal emanating from a petition of the magistrate court in respect of a member of a county assembly? And if so, why?
Yes, a third appeal emanating from a member of the county assembly. My lord, I think the factor here that runs through is also the issue of time. The time given for the hearing of this petition from maybe the lower court up to the time it reaches the appeal court.
So let's take it step by step. So in the magistrate's court, it will take how many months?
I think there's a blanket number of months that was given, 6 months for all.
Okay.
Yes.
6 months. And then in the High Court?
Depending. Maybe even they can take the 6 months in the magistrate's
Okay.
court.
Then you appeal to the Court of Appeal. How long?
If the time has run out, I think there would be a problem doing all those appeals.
So your understanding is that because of the time frame, the Court of Appeal and Supreme Court may not have jurisdiction.
Because of the time,
Because
they
of
may
the
not,
time.
as of what I see.
Okay. So if you prosecute your case fast enough,
Yes.
you will be able to get to the Supreme Court.
No.
So what is the distinction? You tell us.
If it has to go to the Supreme Court, then it's just on those two issues of actually it should be on that issue of interpretation only.
Yes.
But otherwise, it doesn't have to go to the Supreme Court.
So what is the jurisdiction in a third appeal to the Supreme Court? So does the Supreme Court have jurisdiction to deal with a third appeal?
Depends on the circumstances. What are the issues that
tell
have
me
been
the
raised?
circumstances.
If it has to go to the Supreme Court, we just follow the jurisdiction of the Supreme Court. What is it that the Supreme Court can be able to do?
Okay.
Yes.
And in terms of the Constitution, the Elections Act, what is the jurisdiction of the Supreme Court?
Yes. Jurisdiction of the Supreme Court is to hear presidential petitions. Or am I?
No. In terms of, that is original. We are dealing about appellate jurisdiction.
Yes, appellate.
In election, specifically in election petitions emanating from the magistrate's court.
If it has to be on appellate jurisdiction emanating from all the way from the magistrate's court, will it be to do with an interpretation of a constitutional issue in that petition?
Okay, that is your view.
That is my view.
Okay. On the same issue, again, this is a case you did. One of the cases that the submissions you gave to us.
Yes.
One of the issues was there was a case where you sought an injunction in respect of a plot somewhere in Bisil, isn't it?
Yes.
Simple case of an injunction. But I noted from your submissions, you cited extensively Article 60 and 62(2) of the Constitution because it appeared that there was a dispute as to ownership. The court dismissed that application, isn't it? The High Court, at least I looked at the reported case. So tell us, under what circumstances this particular case would proceed up to the Supreme Court? Or rather, under what circumstances would the Supreme Court have jurisdiction to deal with this particular case?
Yes, my Lord, I just came to know after I'd filed it that the matter actually was taken to the Court of Appeal. Yes, I may not be able to.
No, I'm just saying.
Yes.
Hypothetically, party comes, you have an injunction, it is dismissed, you talked about Article 60. Under what circumstances would such a case reach the Supreme Court? An application for injunction, a ruling from the High Court.
Yes. From the High Court to go to the Court of Appeal, my Lord, then the Court of Appeal has very limited jurisdiction in terms of allowing some of these prayers, like this one of injunction, under their rule. I think it's Rule 5(2). And if it has to go to the Supreme Court, then, first of all, it must be certified as appellable by the Court of Appeal. Yes.
And what are the considerations when the Supreme Court or the Court of Appeal or Supreme Court is certifying a matter?
What are
the considerations, the factors the Supreme Court or Court of Appeal takes into account when certifying a matter?
Is the weight of is the weight of the application, is it that if it is not given, it will outweigh or it will create more problems other than if it had been given? Like if a house was going to be demolished, that is an example I'm giving. And if we see that, or the court says that no amount of damages can be able to restitute that kind of a person, then to be able to give out that.
That is the test for certification.
Yes.
Okay. Let's move to another aspect. I'm just limiting myself to the work you have been doing. You talked about FGM, and I think you have done a lot of work for the girl child. FGM is a practice that I think that must be eradicated. And under the, are you aware of the Maputo Protocol? Maputo Protocol?
No, I'm not aware of that.
The Maputo Protocol. The protocol, you are not aware of it?
No.
Okay, so I'll leave that question. The final question I want to ask you, one of the cases you submitted is a succession case.
Yes.
And what came out to me was that this was a succession case of the deceased. The deceased, I believe some lady,
yes,
who died sometime. The succession cause was filed in 2008.
Yes.
Correct?
Yes.
Went on, and the submissions were in respect of a summons for injunction filed in 2020.
Yes.
In fact, the submissions are in November. So from the time the succession cause was filed, that is how many years?
2008. That is 2008 to 2020?
To 2020. Yes, that is 12 years.
12 years, yes.
12 years. You would agree with me that that is an inordinately long time.
It is.
It is. Now, you are Chief Justice Yano. Can you tell us some of the interventions you would make to ensure that this kind of case is dealt with expeditiously? These are succession case. Tell us some of the strategic interventions you would make.
Yes, I may want to look at two. One is to evaluate first what could have really caused the delay in that. But when you look at it, is it lack of enough judges to work on these matters? If that is the case, then we work towards increasing the number of judges. If it is, I look at it also from the issues of bringing in ICT, vibrant ICT. ICT is already there and working on it. Also, I would want to look at mediation, and especially what we have right now, the court annexed mediation. I see it working in Eldoret very well. And partially I've seen it Milimani, but in Eldoret it's working very well. And especially on these family issues, because usually most of these matters are taken to the annexed the court annexed mediator, and we are given time. We'd even run from day to day, and we take Usually it takes only about a week or so, and we are through and we get our judgment.
So I hear 3 interventions. You talked about mediation. This is a family case.
Yes.
You would promote mediation seriously,
yes,
and would finish these cases.
Yes.
ICT. This is a succession case. It is in, say, it's in Kajiado. How would ICT deal with this kind of issue? Maybe just give us 1 or 2 points.
Thank you very much, my lord. Yes, it's been a problem really, and especially when filing cases physically. You find that you waste a lot of time. You come to court, you're in the court registry, day in, day out, and you find that you can even take about 2-3 days before even filing a matter. And when you look at it, actually, it's not that they're refusing to take your documentations for filing, but it's the caseload. And I've seen what is happening right now. When we file using ICT, unless there is a problem, your filing goes through very fast.
So let me just pause you there. So this one of 20, it will be filed in a day. But how does ICT make sure it doesn't remain in the system for 12 years?
Yes, my lord, tracking. Tracking is very important. So that it will be easy, just at the touch of the button, the judge or the magistrate will know, really, this matter has taken so long, can it be afforded dates?
Okay.
But you see, like when you file, when we look at our registries, how files are piled up to the roof there, be a bit of a problem for even the judge or the magistrate himself to track. They'll have to depend on the clerks throughout.
And finally, and I'm sure because you have been watching these interviews, you have thought about the last intervention you said would be to increase the number of judges. You are aware we have 40 judges waiting out there to be appointed by His Excellency the President. Tell us how you intend, if you are appointed as Chief Justice, to resolve that particular issue.
Thank you very much, my lord. Yes, the lack of those 40 judges could be said to have immensely contributed to the judiciary being blamed as not really being productive. The question you've asked me is, what would I do to ensure that these judges are processed to come to the mainstream in engaging and doing the judicial, the judicial work in the judiciary, so that to ensure the core mandate of the judiciary is met. As you can see, my lord, from my CV, one of my core leadership principles is teamwork. I really believe in it. And when I look at the constitution of the Judicial Service Commission, I can see it is so well representative. I think almost all the stakeholders in this country are represented, well represented. I would take an easier step. My easy step will be this. Directly opposite me sits the Attorney General of this good country of ours. I'll start caucusing with the Attorney General. First and foremost, I start from here. He is the chief legal advisor to the government. We sit down with the members of this commission. First of all, let us evaluate as members, what is the problem? When did the rain beat us? Let us first of all caucus from here, discuss, exhaust, and come up with a way forward. And for me, if we can be able to do that, come up with a way forward, then if the next way forward is to go and see or meet with the appointing authority, then it would have come. It is an initiative of Judicial Service Commission. So would be there with the Attorney General, and it will be upon maybe the Judicial Service Commission to say maybe the Chief Justice, Bwana AG, another two, move together, go and see the appointing body and ask him, kindly let us have this country move. Swear for us these 40 judges. That way we can be able to use that link properly, because that link is there. It's only that the link, of course, may not be misused, may not be seen to be misused by eroding the independence of the judiciary. And when Kenyans see 2 or 3 people moving together, then even that connotation of the judiciary is been, compromised may not arise. And sometimes I feel like joking. If we have a lady CJ, like for me, I think I just pick a phone call and call Mama Margaret, kindly call me for a cup of tea and get me to know the moods of Mzee. Can he get to hear us? And then I come and talk to my members of the commission, we move and go and meet Mzee for purposes of having this. That's a joke, by the way, my lord. That is how I'm saying it. Yes.
Thank you, Council. Chair, that is the end of my questioning. Thank you.
Honorable Commissioners, Council Yano, I am suggesting we take a break now for about 12 minutes. We'll be back at 11:15. And the Council, our Secretary, Anna Madi, will show you where you can rest. Thank you very much.